Good afternoon, everybody. My name is Jeff Fowler. I'm the president of the Apartment Owners Association of California. We are one of the largest individually organized groups of apartment owners in the state. It's great to have you with us today. And this is our second live stream today. And we actually have a few more coming up. Next week we have Dennis Block. And after that we have a Pathway to Wealth, which you're going to want to register for. We have one on how to prepare for small claims courts. And unfortunately, some of you are going to have to do that to get your rent back. And so go ahead on the AOAUSA.com website and sign up for those events. And you can subscribe to this YouTube channel. Just about everything we do is live, and we'll be able to answer questions at the end. So that's just to get started. And today we're covering the California Rent Relief Program, and specifically for those of you in Orange County, those of you in Ontario and Montclair, those of you that are in LA City, this is really for you. And so our speaker today is a real estate broker and CEO of Bell Properties. He has been in the business for 14 years. He's managing over 100 commercial properties and over 400 residential properties. And it's my pleasure to introduce to you today Brian Lebeau.
Hi, good afternoon, guys. Are we on? Yeah, awesome. I'm Brian Lebeau from Bell Properties. Excited to be giving you some great information this afternoon. I've watched probably hundreds of these videos, and it's the first time I've had the opportunity to present. So I appreciate you guys being available for this webinar. There's a lot of changes over the last year, as you know, and we're going to delve into some of those changes this afternoon. Before we get started, I want to let you know a little bit about us and what we do, who we are. I used to be an office manager at a CB franchise in San Gabriel Valley for many years, worked at a second residential and commercial office for a couple of years, and opened the property management company in 2014. So we've been at it for a while. We're kind of boutique still. We have properties from the west side all the way over into San Bernardino County and down into OC as well. So we've got quite a diverse terrain. We've got remote staff in the corners of all those areas. And so we've got a lot of different rules that we have to abide by. City, LA City, Santa Monica, West Hollywood, Beverly Hills. So we've got really a great handle on the various programs. And so that's what I want to share with you today. A little bit about what we're going to cover: the federal response to COVID-19, the Cares Act, state response to COVID-19, including AB 3088 and SB 91, the county response, the eviction moratoriums, rent relief, and the city various city programs as well, protections and limitations, as well as the legislation ledge updates. So we're going to talk about that towards the end of the presentation. And also towards the end, I hope we have some time to address some of your questions. So hold on to those, or you can start typing them in. And Jeff is going to be helping coordinate those, and we'll get to those at the end of today's class. So let's start with the Cares Act: foreclosure, eviction, moratorium, and forbearances. Cares Act covers federally backed loans, government-sponsored enterprises, Fannie and Freddie, federal housing, FHA loans, Department of Veteran Affairs, and USDA. Foreclosure and eviction moratorium, those protections are in place through the end of June. On to the next slide, we're going to continue to speak about forbearance and eviction moratorium. Forbearance to non-government sponsored entities. Some protections apply when requesting forbearance only. Non-federally backed loans are covered. Rights and responsibilities, forbearance review. And who qualifies? Folks that have first lien, 1 to 4 units, owner and non-owner occupied. And we do have an update from February. The federal district court judges ruled the rental eviction moratorium unconstitutional. Jeff had a great article in Apartment Owners magazine in this month's magazine, talking about the federal court's decision sets critical precedent. Eviction moratoriums imposed by federal governments are unconstitutional. This means that even Congress cannot come back behind this decision and legislate on it. Just flat unconstitutional. Well said, Jeff. And we're going to talk more about what happens now that it's been ruled unconstitutional. What happens next? Towards the end of the presentation, we'll discuss that. So moving right along, California response, AB 3088 was the first bill, and then SB 91, of course, followed. So documentation to work within AB 3088. Financial hardship, you have to prove that due to COVID-19 as of February 1st, 2021. Requests submitted in writing, denial within 21 days with specific justification. Revised request must be answered within 5 days. Post forbearance, loss mitigation options, language used consistent with regular communication. So let's talk a little bit about that. 2020, the pandemic brought just a tsunami of legislation seeking to protect most vulnerable among us tenants who are, I mean, really, if you look at it, tenants are just so overly represented. There's probably 100 tenants to each of us that own properties. So really, we need to be more vocal and be reaching out to our legislators, federal senators, assembly members, state, Chu up in Sacramento. We need to be more vocal and, make a stronger representation and try and halt some of the craziness that's taken place over the last year. So what exactly are these legislations and how do they protect landlords? Well, we're going to take a closer look at Assembly Bill 3088 and Senate Bill 91, SB 91. The key provisions of 3088, landlord must provide notice to its tenants informing them of their rights under 3088. That needed to be done by September 30th of last year. Concurrently, with any notice demanding rent or any other payment obligations under the lease, tenants have 15 days to respond, and that declaration must be signed. It says under penalty of perjury. Doesn't stop most tenants from just filling it out. COVID-19 related financial distress means any of the following: loss of income caused by COVID-19 pandemic, increased out-of-pocket expenses directly related to performing essential work during COVID-19 pandemic, responsibilities to care for children. I won't go through this entire list, but households making more than $100,000 annually and more than 130% of the county's median income, whichever is higher, are going to be required to provide that additional documentation showing financial hardship. I know there's been a lot of questions about how do you prove that if your tenant moved in and they were making X dollar amount and you don't have records on it. You have to go based on the documentation that you would have in-house, probably dating back to their application, right? Unless you did a renewal and you got updated information. So AB 3088 also includes provisions that clarifies already enacted provisions, Tenant Protection Act, AB 1482, to rent increases, clarify application of the laws to protect properties containing two housing units, aligns definitions, corrects erroneous cross-references, and clarifies the scope of laws with which a housing provider must demonstrate compliance before establishing new rental rates after the expiration of the affordability covenants. Let's move on to the next slide. Again, AB 3088 and SB 91. So Homeowners Bill of Rights, HBOR, provides procedural protections to homeowners before a foreclosure sale, requiring mortgage servicers to contact borrowers to discuss foreclosure prevention alternatives and pursue foreclosure proceedings if loan modifications are under review. AB 3088 extends protections to small landlords. AB 3088 extends HBOR protections to small landlords owning a fully tenant occupied property with 1 to 4 units if the following conditions are met. The landlord owns a maximum of 3 residential properties, each of which contains a maximum of 4 dwelling units. The property for which the landlord is seeking protections is occupied by at least one tenant who has been unable to pay rent due to COVID-19 financial hardship. The property for which the landlord is seeking protection is occupied by at least one tenant who entered into a market rate lease that was in effect March 4, 2020. Now on to SB 91. 91 closed certain loopholes and inconsistencies identified in prior legislation related to how debt can be collected via courts, capping attorney fees for debt collection services, prohibiting small claims filings for recovery of COVID-19 rental debt accrued from March 20 through June 2021 until August 1st, 21, and other court filings until July 1st, 2021. So July 1st, 2021, that's when we're going to be able to start doing 3-day notices again and returning to a bit of more business as usual. SB 91 also grants courts the authority to reduce the damages awarded if a landlord refused to help from the state rental assistance program for a tenant, permanently prevents the sale of COVID-19 debt if tenant would have qualified for federal state relief funds. As you're aware, things are changing quickly, and the aid measures and interpretations described may change and are subject to wide interpretations. This information is just really our best understanding and interpretation based on where things are currently, and is not intended to address all potential legal risks to be a definitive statement of law. Let's move on. Under SB 91, $2.6 billion from federal government is going to be available to pay off rental debt for eligible households at or below 80 AMI, that's area median income, with the priority to those under 50. I think by and large, the counties and cities that we're talking about today, 50% is the criteria for the first round. And in many cases, overall, the funds that will be distributed are limited to households with 50% AMI. We're going to go through those in just a little bit. Participating landlords, 80% of tenants' total unpaid rent is going to be provided to landlords. Under 91, landlord must accept payment in full and agree to forgive the remaining 20% owed in back rent. Everyone knows about that 80-20 rule. That's a state program. Landlords unwilling to participate, eligible tenant households can still apply, and if tenant qualifies, landlord can receive a 25% direct payment for tenant's unpaid debt. The 25% is going to be due and payable by the end of July, which means you might have the last 4 or 5 months of unpaid rent. Do they have to pay that percentage every month? No, it's not due until the end of July. At that point, tenants would be evictable. A 3-day notice would be served. The 75% back debt is transmuted to civil debt, and you can pursue that in small claims. The limits have been raised for small claims cases. So, if you have 4 months of back debt at $4,000 a month, you're going to have $16,000. So 12,000 of that would be pursuable through civil courts, small claims, even though it's over the previous limit for small claims cases. So before applying, you're going to need for landlords, IRS W-9, verify residency in one of the following ways: with the lease agreement, program ID with license, official letter from third party showing name and address, government issued library card, so on and so forth. Verify ownership, one of the following with property deed, mortgage note, property tax forms, homeowner's insurance. Everyone should have those, right? So this next slide talks a little bit about the timeline for the California state protections against eviction for non-payment of rent. So, if you want to copy these slides afterwards, you can send me an email. I'm happy to share the slides with you. I don't think we have time to dig into every last detail. I think this is pretty common knowledge, and we talk about it in other ways. And so if you want a copy of the slides, you can email me directly at brian@bpnc.org. mgt.la. And there's a little bit later on, there's some hyperlinks that we will visit. And so you will have those links as well. If you want to copy the slides, just let me know. So here's the list of forms. We've been inundated with changes and new forms and new policies, new procedures over the past year. And this is a list of forms just really for your reference. I'm not going to go through them. Most of you know the stack of forms that you have to serve now. It's not just a 3-day notice, of course, it's a 15-day notice, informational notice. And there's also in the second column, when to utilize those specific forms. So happy to share that with you if you send me an email. So now we're going to dig into the various county programs, and we'll go out and visit the San Bernardino County website, and also the cities that are carved out of the county program. We'll visit their websites as well. So for the county, San Bernardino County program, you have to verify that rent is owed by one of the following documents. Pretty straightforward. It bans evictions for residential and commercial tenants impacted by COVID-19. San Bernardino County is composed of 24 cities. Properties within Fontana and San Bernardino City are not eligible for the county program. So I wanted to switch over and show you briefly the county program, San Bernardino program, and Fontana program. So this is the San Bernardino County Rent Relief Program, and this is based on 50% area median income, right? So household of two, 50% would be 30,000. So, I mean, I think the whole program is pretty difficult to get your tenants with everything they're asking tenants for, everything that landlords have to provide. We manage over 600 units, probably a good portion in San Bernardino County. Of course, the bulk of them are in LA County. And so we've done.
Hey, Brian.
Yes, Jeff.
Brian, just real quick, can you switch to the slideshow mode so we can see it a little bit bigger? Right now, it's hard to see it.
I wonder if it's possible to zoom in on this one. Oh.
A little much.
All right, let me jump back to the slides.
Oh, that's fine.
Yeah, when you do the slide, like we can see the tiles on the side. So I think there's a slideshow mode. Yeah, there it is.
16.
There we go. Thank you so much. Sorry to interrupt you.
No worries.
You're doing great. Thank you. I'll butt out now.
No worries. Jump in anytime. So San Bernardino County, there's a lot of ways that your tenant may not be able to qualify. I think the first and foremost on everyone's mind is, the tenant's mandated to supply quite a bit of information to the county. Landlords can initiate the claim, but the onus is highly placed on the tenant to provide documentation relating to income and other things. So that's been the biggest question that's come up as we've talked about these programs is, what if my tenant leaves? What if my tenant doesn't cooperate or fill out the forms? These are all gray areas. It's not, these things have not been addressed. I think that, it's going to take phone calls to the counties or the cities that are involved in these programs to flush out what wasn't ironed out when they initially wrote these bills. So that is San Bernardino County programs. And if you guys want more information on the city of San Bernardino and Fontana, I'm happy to provide you those details offline. This is also a link, kind of a matrix that will, if you had the slides, you could jump out to the city programs, San Bernardino County boundary. And so if you want to copy this, I'm happy to share it with you. Just send me an email. So let's jump down to Orange County. Let's take a beach day. What do you say? Okay, so Orange County. Orange County is, the program is open, of course, April 1st to April 30th. It's coming up to a close in a couple days. There's information on the website. Each county's program is titled a little bit different. For Orange County, they're calling it ERA. I think LA is calling it ERAP, Emergency Rental Assistance Program. So each county is calling it a little bit something, a little different. So for Orange County, households need to be at or below 50% median income, regardless of employment status. So 44,850 for a household of one. The criteria is pretty challenging, I think. Once your tenant even qualifies and submits all the information, once they get past that hurdle, they still are not guaranteed, funds have to be available. And also they're doing it like a lotto. So if you have 1,000 people that start out at the beginning, 500 maybe qualified. Out of those, funds availability is going to come into effect, as well as, just how they draw those names. So for Orange County, the cities that are excluded from the OC general program are Santa Ana, Irvine, and Anaheim, Santa Ana, and Irvine. So those cities are doing their own programs. Criteria is similar, but not the same. The timing is similar, but not the same. And again, if you'd like a link to those programs, you can request the slides. I'm happy to share them. And these are hyperlinks on this next slide that would jump us out to those various programs, the city and the county programs within Orange County. So the behemoth in front of us is LA County. And in this next section, we're going to talk about LA County and LA City. So first up, LA City. So LA City, tenants and their landlords who agree to participate in the ERAP will receive 80% of unpaid rent April 1st through March 31st, 2021. So beginning of April last year through the end of March this year to be approved, landlords must accept the ERAP as payment in full for all rental debt for that period, including forgiving the 20% balance. So what if you don't want to forgive the 20% balance? Tenants whose landlords choose not to participate in the ERAP are still eligible to receive 25% of the back rent owed for the rent between April 1, 2020 and March 31st, 2021. This will meet the requirements for eviction protection under SB 91. So the website for LA City program is HCIDLA, is administering the city rent relief program. Some more information on eligibility. Eligible applicants will be chosen through a random selection process to participate in the program. The program is required to give priority to paying past due unpaid rent. If selected, the program can pay 80% of a tenant's past due rent for the period of April 1 last year through the end of March this year, but only if the landlord agrees to waive the remaining 20%. If a landlord does not agree to these terms, the program can pay 25% of the tenant's past due unpaid rent, as well as up to 25% of the tenant's upcoming future rent for 3 months. These rules are in alignment with regulations in SB 91. More information and details, hcidla.lacity.org. And we've submitted the landlord portion on probably 20 residents on this within the past 3-4 weeks. And we've heard one response back earlier this week. We've had one response back, and that was they're waiting for the tenant to fill in their information. So we're not super hopeful that those requests are going to be paid. LA County Rent Relief Program. Sorry, this is the city of LA. Eligible applicants will be chosen through a random selection process to participate in the program. The program is giving priority to past due rent and unpaid rent. If selected, the program can pay 80% and landlord waives 20%. City of Long Beach. self-explanatory there. And landlords seeking to expedite the process of reimbursement are encouraged to pre-register online. And I think the time frame for that has passed for the city of Santa Clarita. So again, hyperlinks here to the various programs for the county program, the city program, Long Beach, Santa Clarita, and City of LA, of course, are carve-outs not being served within LA County for those residents. Those cities, of course, have their own programs. So the City of LA, in partnership with the state of California and federal government, created 2021 COVID-19 ERAP to assist residential renters who have been unable to pay their rent as a result of COVID-19. LA Housing and Community Investment Department, HCIDLA, is implementing ERAP. So here's more information and details on the county programs for the cities that are not excluded with the other, LA City, Long Beach. These other cities within LA County will be served by this program. And that's the LA County Eviction Moratorium, which started March 4, 2020 through September, the end of September last year. That was the first period. That placed a countywide ban on evictions for residential and commercial tenants, including mobile home renters. Under the county's moratorium, tenants may not be evicted for COVID-19 related non-payment of rent, as well as no fault reasons, nuisance, denying entry to a landlord, or unauthorized or occupants or pents if related to COVID-19. So, again, it's up to whatever the tenant says. I mean, tenants can say under penalty of perjury that the unauthorized occupants are due to COVID-19, and who knows if that's going to be, we can't really look at that. So between October 1st, 2020 and June 30th, 2021, the county's moratorium does not apply to residential tenants facing eviction for non-payment of rent due to COVID-19 for financial hardship, as they are covered under the state's moratorium. So who is covered? Residential tenants, commercial tenants, mobile home space renters, and the moratoriums March 4, 2020 through June 30, 2021, unless repealed or extended. And I'm looking forward to Dennis Block's presentation next week when he can shed some light for us on what happens at the end of June this year. Hopefully this all goes away. So residential tenants are, evictions are prohibited for non-payment of rent, late charges, or any other fees, COVID-19 related violations, nuisance, no fault eviction reasons, denying entry to a landlord, and rent freeze. For commercial tenants, non-payment of rent, late charges, or any other fees, as well as harassment. So, protections and limitations. Does it mean that tenants don't have to pay rent? I think my honest answer is it means our legislators don't stand up for property owners, but commercial tenants are responsible for providing notice to their landlord if they're unable to pay rent due to financial impacts related to COVID-19 within 7 days after rent is due, unless extenuating circumstances exist. Tenants with 9 employees or fewer may self-certify their inability to pay rent to their landlord, either orally or in writing. Tenants with 10 or more, but fewer than 100 employees will need to provide written documentation that demonstrates inability to pay rent due to financial hardship related to COVID-19 to their landlord. If they're able to do so, tenants are encouraged to pay partial rent during the moratorium. Encouraged. All right. Getting close to the end. Legislative updates now. Protections and limitations. So as of February 2021, LA County Board of Supervisors extended and expanded the eviction moratorium, as we know, extended the temporary eviction moratorium through the end of June to the extent protections are not preempted by the state rules, AB 3088 and SB 91. includes administrative fines and penalties for violations of the moratorium in accordance with the county code, waives the RSO registration fee requirement for property owners in the unincorporated area of LA as long as they register by the end of September this year. AB 3088 protects most residents from being evicted for non-payment of rent if related to COVID-19 financial hardship. Preempts certain local protections for this category of residential tenants, requires landlords to provide written notice of unpaid rent, copy of tenants' rights under the state bill, and sample declaration of hardship. So that's what we talk about when we talk about the 3 or 4 items that must be posted along with the 15-day notice. Requires tenants to pay 25% of unpaid rental balance and submit a signed declaration to the landlord for each month tenant is unable to pay rent due to COVID-19 related financial hardship. So every month that has to be posted, and you can just update the same form with the new month's rent, and you wouldn't add, in, you know, if you have any pet rent or utilities, only the rental balance goes on that 15-day notice. So a little bit more into SB 91. It is in effect through the end of June, extends protections, noticing requirements, and certification requirements for landlords and residential tenants, as well as local preemptions under AB 2088. Sorry, that's 3088. Includes state rental assistance component, residential tenancies, evictions for non-payment of rent due to COVID-19 hardships are not covered by the county's moratorium for the period of October 1st through the end of June this year. Tenants required to provide their landlord with a signed declaration of hardship in accordance with state requirements. We talked about that, and all other local county protections remain in place for all of LA County and no impact for commercial tenancies. So under the state program, SB 91 and AB 3088, first for the first time frame, protected time period, 15-day notices in the info sheet and declaration, quoting AB 3088, 15-day notice to pay rent in full or sign the declaration. All that rent is now referred to as civil debt. And we have to wait until August 1st this year to start small claims process on that unpaid rent, which has been parlayed. The new term for that back due rent is civil debt. Tenants cannot be evicted if they submit a declaration to the landlord verbally or in writing. Tenants have until the end of September to repay unpaid balance accrued during this time. During the second period, SB 91, September 1 through the end of June this year, tenants are protected from eviction if they send a written declaration to the landlord and pay at least 25% of their unpaid balance by the end of June 2021. And an important note on that 25%, I alluded to it a little bit ago, but they might have turned in that written declaration month after month after month, and you might have 4 or 5 or 6 months back due. And that 25%, that unpaid balance, whatever it is, let's say $10,000 is their unpaid balance for easy math. That 25% is due to you by June 30th. So they cannot pay anything until June 30th. So tenants have until the end of August 2022 to repay the remainder of unpaid balance accrued during this time. We know collecting that money is going to be challenging, if not impossible, as tenants walk away from that debt. So unlawful detainer actions can be filed now. Tenants didn't return the declaration or pay the 25%. Those are 2 instances where you can initiate a unlawful detainer. Dennis Block, be happy to help you with that. We have a couple evictions in process, probably 5 or 6 going right now with Dennis's office. July 1st, UDs can resume July 1st with the 3-day notices. So unless the current protections get extended between now and the end of June, we can return to somewhat business as usual with the 15-day notices going away and to start implementing the 3-day notices again. So more information about the mortgage relief program under SB 91. And a couple questions here, and we will get to your questions. So this one came up a lot as we were explaining it to our owner clients. Is the 80% paid out directly to the landlord or paid out to the non-paying occupant? From what we've read, we haven't experienced this firsthand because we haven't received any of those funds yet. That 80% should come to the landlord. If after 6 months of submitting COVID notices to the landlord, a tenant has ceased communication, abandoned the unit, can the landlord receive relief without the tenant's participation? From what we've read, there is no cause, there's no action, there's no path to remunerate landlords if the tenant is not still in that unit, and if they're not cooperating with completing the documentation. What other cities in LA County have a temporary eviction moratorium? We know that LA City has their own program. And regarding the CDC order, we know that Texas and Tennessee judges have ruled that the CDC moratorium was unconstitutional. That is the eviction moratorium. John Barker was a judge, declined to issue an injunction against the CDC's rule, but he said he expects the CDC will respect his decision and withdraw the moratorium. But so far, CDC has not issued a statement or withdrawn the moratorium. So we'll have to just wait and see what happens with that. Another rule that came out within the past couple days, yesterday, Consumer Financial Protection Bureau issued a rule, and I got this from National Association of Residential Property Managers. The Consumer Financial Protection Bureau, CFPB, has released an interim final rule that would, in their words, provide debt collectors, including attorneys seeking to evict tenants for non-payment of rent, must provide tenants who may have rights under the CDC order with clear and conspicuous written notice of those rights. Notice must be provided on the same date as the eviction notice, or if no eviction notice is required by law, on the date the eviction is filed. And the kicker is that it must be in writing, on paper, not via email. And the rule basically does the following: debt collectors who want to evict tenants who may have rights under the unconstitutional CDC eviction moratorium without providing notice of the moratorium, who misrepresent tenants' right under the moratorium, can be prosecuted by federal agencies and state attorney generals for violations of fair debt collection practices, and are also subject to private lawsuits by tenants. As an interim final rule, this would take effect May 3rd of this year. Interim rules are where an agency believes that a rule is needed with such haste as to promulgate it without comment. It could be later altered based on comments or actions by the court. So that is it for me. I want to thank Jeff and the Apartment Association for having us on this webinar. Matilda Gonzalez is standing by with me now to answer your questions. And again, if we run out of time, please feel free to email your questions to us. My personal email is brian@bpmgt.la. If I said it too fast, it's there on your screen as well. Or you can call me. Direct number is 800-341-3281.
Great. Thank you so much, Brian. And we have some questions here. So I'm glad that you guys listened all the way through, and then now you're going to ask questions. So that's great. And we'll go ahead and get to it. But before we get to the questions, some of you may have tuned in late, but Dennis Block will be speaking next week, and we have a couple other live streams coming up. And one's a pathway to wealth that you'll want to sign up for, and another one about how to prepare for small claims courts. And so those are different ones that we just anticipate. There's going to be things that you need to know about it. So go ahead and subscribe to the YouTube or get on the website and just register for those events. And then also just wanted to highlight one thing about AOA. We have over 150 forms. We're up to 150 now. California is complicated. And we have forms to help you with that. And then we have advisors to help you know when to use those. And anyway, as we get started here, everyone can look at the law a little differently. And so just a disclaimer that Brian's going to be sharing maybe what he would do in his situation, but he may not understand your situation fully. And so it's not legal advice, but just kind of maybe what he thinks would work. And lots of times he's going to refer you on to an attorney. So here we go. Go ahead, take it away. Oh, I'll take it away. I got to ask a question first. Okay, Patricia on YouTube. I applied for rent recovery with the state under the COVID-19 Relief Act. Do you have any notion about how long this process might take the state to pay the 80% grant funds?
Yeah, it's a great question, Patricia, and I thank you for it. We've had probably about 5% of our residents needing various relief programs, from state to the LA City program, and we have not seen any funds come back. I think the last one we did, or the earliest one we did, was 3-4 weeks ago for the 80/20, the state program, and we have not had a response from them. The LA City program, we've had response within about a week, asking for more information, or that they were going to be reaching out to tenants. But so far, I don't have an answer for you. Sorry. On the state program.
Right. It's just kind of like everything that's run by the government just is going to go slower. If this was a privately owned company that was incentivized to get these things out, man, I bet all this stuff would have already been divvied out. But that's just how it works when you have the government run things, right?
Absolutely.
So Brian, we can't see we only see a picture of you. Can you share your video with us?
Trying to click the button. I think I'm locked out from resuming the video. Somebody can unlock me. The host. Maybe Israel can unlock me.
I don't have a control on it. But we'll go to the next question and we'll see. Maybe Israel can give us a little coaching on how to get that done in a minute here. And on YouTube, Diane, we have, hi, I have a tenant who was filing for COVID declaration. She ended up passing away. She has no estate. Am I allowed to apply this to the state for the month she owed? The property is located in the city of LA.
Yeah, it's another one that really falls within the gray area. I would say, yes, apply for those funds. And there's an area, I think the city of LA's landlord portion, the form is about 17 sections, and go through there. And at the end, there's a section to make some comments, and you can explain that that person has passed away.
There we go.
There I am. And submit that. I would say if there's questions, or you're not sure, or the tenants left, or tenants passed away, best just to go ahead and get that application submitted. If there's rent owing, those programs are still having funds. Yeah, I'd say submit.
Was the LA City one, was that first come first serve, or was that one a lottery?
It is, I think it's just based on funds availability, and then qualifications, and then a lottery in the backside. If they have a pool of 1,000 people that are qualified, they're going to use a lottery system to define who receives those funds.
Great. We have a very, very extensive YouTube live stream that we did back in March before we hit April 1st. So you could look at that one. It's very extensive with lots of questions answered at the end. I would refer to that one for everything related to LA City, because we focused on that one, really took a deep dive there. We had another live stream that was Northern California. And so this one, we're trying to cover the rest of Southern California. But here we have Audrey, and I gave my tenant the SB 91 form, and they have not wanted to submit documents needed on their behalf. They have not paid for rent the past 7 months and began paying 25% in February. What would you do, Brian, if you're
I mean,
operating that one?
I would be on the phone with Dennis's office because they're coming up to the end of the run here. So, you know, I would start moving forward towards filing unlawful detainer on those folks when it's going to be available again, August.
Great. And then Emmanuel on YouTube. If a landlord gets funds from the rental assistance program for past due rent, can this payment render eviction to be dismissed? The eviction is due to nuisance. Eviction filed April 15th, 2021. Rent is due from August 2020 through April 2021.
So if he's got someone that he accepted funds within either the Assembly bill or the Senate bill, the statewide programs, and he's accepted funds through those programs, he is not able to evict based on non-payment of rent. But there could be other issues that, depending on where it is, that would allow him to evict for nuisance. You know, if the tenant is threatening the owner, there are other ways, and Dennis is expert at getting those things to progress.
Okay, this is Tierra del Sol Apartments. I know I have a couple of tenants that applied for the rental assistance. Do owners have to apply at the same time or wait for a response from the LA City?
Yeah, so the LA City program, you can do it simultaneously. If the tenants have applications in progress, LA City is going to reach out to owners and say, you know, we have these completed applications that are waiting, and they're going to ask you for the W-9 and the other owner information so that they can progress and get you qualified to be in the drawing.
Great. And Hannah on Facebook, do you think they will extend the eviction bans? We just want our property back. Non-paying tenants destroying the property.
Yeah, it's terrible. I think, you know, we should all be calling our representatives because certainly this has gone on for way too long. We know it's not right. We know it's not fair. There's never been a time in any other industry where grocery stores are asked to give away their products, or restaurants are asked to give away their products, or employees are asked to work for free. So I think we just really have to be a lot more vocal than we have been and put an end to this. I can't imagine that it's going to be extended, and I would be interested to see what Dennis has to say about that if he's got more insight. I cannot imagine this going on any longer.
Right. You know, and it's amazing that you have to, it's not just that you're giving them something, but you're like serving them and you're working. And so really this is forced labor. And it's just incredible that this is happening in 2021, that we have forced labor imposed on a specific group of people.
Right. I feel terrible for the small landlords that have buildings that require maintenance. They don't have money coming in. They're paying their mortgage, and they've got to make repairs and, you know, keep the heater running. And it just seems insane that this could continue.
Okay, Audrey on YouTube. Can I get landlord assistance without my tenant filling out the information needed? Looks like they really don't want to do their part. Yeah, thank you for your advice.
Yeah, right now there's no system in place for LA City landlords to get those funds without the tenant complying with their portion. I would still go ahead and submit your application, submit your information, tell your tenant this is a major advantage for them because they're getting free money. So try and encourage them, let them know that you've applied on their behalf. They're going to get a letter. They're going to get email and correspondence from LA City regarding this program that's going to help eliminate some of the debt. Dennis Block's office is also offering a great service. I think for $200 or $300, they will write a letter to your tenant, letting them know this money is not just going to go away at the end of the protections. This money is going to be owed. So, I think that's a strong way to potentially proceed as well. Try and talk to the tenant, let them know that the money's going to be owed, and then, give Dennis's office a call, because they can write those firm letters and help your tenant understand that this money is not just going to go away. This debt is going to be on their record.
Right. How do you avoid a harassment at this stage? And what's the balance there with all that?
Yeah, it's important to try and be very cautious when talking to tenants. I think there's a fine line between sending someone a notice, posting a notice, and maybe do a posting, post it on their door, take a photo, timestamp that photo, and then maybe one phone call. I can't imagine that could be construed as harassment, but certainly you want to find that fine line and stay on the safe side of it.
So that's what you're doing?
That's what we're doing, yes.
Great. Okay. All right. Jolly good. I like your handle there on Facebook. Does Orange County qualify for the 80-20% or just up to the 10K?
Yeah. The OC program, if you are in, let me go back and look at the notes on the OC program, because I think we went over that fairly quickly. And I don't know if you guys can see my screen, but so Orange County is based on the AMI, based on the median income area, medium income. So you have that hurdle to jump through. And then
you said 50%, right?
Yes, 50%.
Yeah.
And that's $44,850 for one household with one person. So I'm not sure did that answer the question? Was it whether or not
the question again? Yeah, does Orange County qualify for the 80%, 80-20 or just up to 10K? So they have to meet that income level, and then it's 80-20. And then it's just capped at 10K. That's kind of what she's wanting to.
Exactly. Well said. That. Well said, Jeff.
Well, I was asking you. Okay, great. On YouTube, let's see. Okay, Diane, we're gonna go in order because we got a couple people in line. We're trying to, like, if we ever had our $1 million seminar, COVID's kind of wrecked everything for now, but when we get back to the Long Beach Convention Center and the LA Convention Center, we just make a line and everybody gets one question, and then they get back at the end of the line, and then when they come back up, they can have a question.
Very straightforward.
Yeah, just going like that. So we're going to go with WT, and then we'll get back to Diane here in a little bit. If tenants don't pay rent and they refuse to proceed with the rental assistance, can a landlord send the back rent amount to collections? And they're in the East Bay.
Northern California, East Bay, like Oakland area?
Probably so. Yeah, probably so.
I'm not hyper local. I grew up in the East Bay, Northern California, East Bay, Livermore. If anyone knows it, raise your hand. But I believe what's going to happen there, they are not complying. You're not going to be able to get that, the county program, the 80-20, maybe not. Maybe they won't even qualify for the income criteria. So I think that would go to unlawful detainer and potentially civil small claims.
Right. One of the AOA services is the debt collection, and you cannot even attempt to collect, if I understand correctly, until they've actually left the premises. Brian, what's been your experience with that, with trying to collect a debt?
Yeah, I mean, it's a terrible situation. We had a recent eviction where the tenant got it so that we couldn't report the debt on their credit. I mean, I think just California judges are so lenient on tenants. Mm-hmm. Anyways, yes, they do have to be gone from the property. And, debt collection services are not cheap. I think AOA offers a great service to pursue tenants that, they need to have this documented. This needs to be on their credit report. This needs to live with them for 6-7 years. So I would encourage anyone that's going through the process to, not just go after them in small claims, but also, whatever the judgment is, you got to turn it over to collections as well.
Yeah, and then there are some cases where you just can't do it too, if COVID related stuff. So it's kind of like we're processing a lot of those, like, yeah, a bunch of them. We're processing those, but the attorney that's doing it and working with us, there's certain ones that he says we can't do this right now, and in the appropriate time, in the appropriate way, they'll get processed.
Yeah. And I think it's important to have in mind that even though the money may never come back to you, and most firms that do the collections are doing so on a percentage basis of whatever is collected. But more important equally important with collecting the money is having this on their record. So that's why I encourage everyone to do it when possible.
Right. And, it's kind of funny. Last night, there was a news anchor that said, it was regarding the judgment with, the George Floyd trial, and just saying that really justice starts with accountability. And I think that's what this is. Totally, obviously, completely different circumstance, but it's criminal activity, just as murder is much worse, but to not pay your rent, it's criminal activity. And to hold people accountable is really at least the first step. And so we really do encourage it. And yes. Yep. So I'll stop there.
No, it's true. I think that, California tenants have the mindset that, I don't have to, I've got, COVID protections. I'm not going to get evicted. It's not going to follow me. And certainly, once this is kind of implemented, and, I think the more we do this as an industry, the better it helps us in the future to try and, let tenants know that this is what happens.
Right. You can't have a sustainable community or financial things just don't work without the accountability in there.
Right.
So, let's see. Okay. Rumana. Tenant has not replied to phone calls, texts, letters. He ceased all communication and did not apply for rent assistance. Can I evict based on the lack of communication?
So there was never a COVID declaration?
Yeah, so it says that they have not replied in any way to any communication. Yeah.
So if there's no COVID protection, what's really tricky is people can not send in the COVID affidavit, and then they get to court. They're given another opportunity to say, "Oh no, it was I was affected by COVID." So that aside, she might have to wait until the eviction moratorium expires, and then proceed with the 3-day.
Have you had anyone like that in any of your properties?
We have a good, probably have a total of 30 folks, 30 households that are at various stages with various programs. And a lot of them, the really terrible thing is, like, some high income, we know they're high income. They may not meet that 130, but we know they're high income households that haven't been affected. So that's really the worst ones that stop paying to try and take advantage of some of these COVID protections. But yeah, it's a good percentage of folks that are just not responsive.
So your approach is to just wait.
Yeah, right now that's our only option, is to really wait it out.
And I know some people, they're saying, hey, take it to court, and if they show up, then it gets put off and you have to pay more, but there's the chance that they may not, and that it can go through. So it's kind of you're taking the conservative route. People could be more aggressive if they wanted, but there's just that a good chance that the tenant could show up and with that little form. So,
Yeah. Hey, I was COVID affected, right?
right. All right, next one. Hi, can the landlord apply 80% for those who moved out and owe rent? If it's in that period that's covered and they've already moved out.
It's again, one of those gray areas. I would say apply. And if the tenant moved out owing a certain money that was during the eligible time frame, there's an opportunity there. I think that could be utilized. I don't know if they're going to honor it, but I would still apply for sure.
Okay. Jackie, what would you suggest if the tenant has no email address?
I think most tenants do have email addresses. I think you can probably Google search or white pages for email address, or call them on the phone and say, hey, I need to send you something. What's your email? I assume they're probably just non-responsive, in which case it might drag out to the point where it has to go to court under UD if she's not able to get their application in time. Time is running out for those April applications are for those that are still open. The deadline is the end of this month. So yeah, I'd say get those applications in. Even if you're missing a bit of information, get those applications in.
Okay, we're going to take one more question. I know that you have a hard stop, so we'll just take one more unless it's real short answer. Dakar, is LA City rent relief capped at $10,000?
For per household? I guess she's talking about per household, right?
Right, because in Orange County it is, but
yeah, I haven't seen that number float around with the LA City program. I don't know that they have that that firm of guidelines.
Yeah, I haven't seen that anywhere either.
I haven't seen 10,000 associated with the LA City program at all.
Right. All right. Well, thank you everybody for joining. And I know that everybody got at least one question answered. If you have more questions, you can call Brian, you can call AOA, you can call Dennis Block, you can call whoever, and maybe we can give you a little more help. And anyway, Brian, thank you. This is, Brian's just doing this, and so he's kind of giving to the community. So let's give him a thanks. And
thank you guys.
Also just want to remind you, next week we do have Dennis Block coming up, and then we have these other live streams with live Q&A. So go ahead and sign up for those on the AOA website, aoausa.com. And then there's an events tab. If you click on that, you can pick the ones that you want, subscribe, and join, guys. Did you know that if it's your first time to join, it's 100% money back guarantee for that first year. And so go ahead and sign up, get your membership, get your forms, and let's make sure that you don't make any real costly mistakes. And we got a lot of other ways that we're trying to help you make more money. And also, just for what it's worth, AOA has property management software now. If you're interested in that, you can go ahead and you can call me. My name is Jeff, and just call AOA and ask for me. And you may have to leave a message. It just depends when you call. I may be on the other line, but I'll let you even try this software. Test it out for us. We're going to be testing it. We already have a couple hundred users on there, but just want to make that available. And soon it's going to be connected to the AOA tenant screening and the AOA forms. So it's going to kind of bring everything together for you and make life a little bit, make this passive income thing a little more passive, hopefully.
Nice.
Brian, any last words before we sign off
Jeff,
here?
Thank you for having us. I really appreciate the opportunity to be here and share what we know, and share how we can help folks. And again, if folks want to get a hold of the slides, I'm happy to share them. Brian at bpmgt.la.
Great. Thanks, Brian. And thank you, everybody. We'll see you next time.
Bye.
All right. Thanks, Brian.